And I would just remind everyone at this time that we are live streaming. Now, ladies and gentlemen, this is the part of the case in which the lawyers for both sides are able to give closing arguments to you. I want to remind you what we said at the beginning, that what the lawyers say is not evidence. What you're about to hear is they're trying to persuade you to their side of the case. The state has the opportunity to go first and last, and the defendant attorney will argue in the middle. So at this time, I'm going to call upon the state as to whether it has any closing argument to present to the jury.
Yes, Your Honor. Thank you. So much. That's the second to last time you have to watch me struggle with the technology, I promise. Ladies and gentlemen of the jury, over the past 3.5 days, we've been hearing the state of Georgia versus Leon Jones, and that's 17 SC 154313. That number is anything other than the fact that this case was indicted in 2017, and 154 case indicted in state records using the system. I have no idea. This is the case of the state of Georgia versus this defendant. Maybe. As soon as we're finishing our closing arguments, this is about two documents. Each side is about to talk to you. And because we're lawyers, we're going to take the judge is going to instruct you that a crime is a violation of a statute, a law passed by the legislature, in which there is a joint operation of act and intention. An act in this crime, in these crimes, is the act of beating your victims. And the intention may be shown in many ways, provided that you, the jury, believe that it existed from the proven facts before you. The intention to violate the law may be inferred from the proven circumstances or by the acts and conduct, or it may be in your discretion, inferred when it is the natural and necessary consequence of the act. The crimes are aggravated battery, 2 counts of aggravated assault, and false imprisonment. Ladies and gentlemen of the jury, after all this time, it all comes down to 17 minutes. On September the 5th, 2007. Those 17 minutes start at approximately 8:34 a.m. When Little Squirt crawled through the front window of 592 JP Brown. How do we know that Little Squirt crawled through the window? Because he's wearing an ankle grip, and the GPS signals that broadcast computer from the detective slush once a minute put him at that specific location. And as it turns out, the latitude and longitude correspond exactly with that address. Detective Sluss told us how that is all figured out, and that sure enough, at 8:34, he's at that location. On cross-examination, that's going to point out that he was moving around that location during the time, which is consistent with the testimony of Amber May and Susan James. In the window, in the back of the house, in the living room, went to the front bedroom or front room where Susan James was laying on a cot. He came in that location and he immediately began yelling, "Where's my kid?" Telling the occupants of that house, they're not owners or residents. They're occupants of the house that you can see is boarded up and that you saw is in terrible disrepair. Ladies and gentlemen, you will have those exhibits back in the jury room. You will to see again the state of that house. Where at least two people, and as in this world, will serve on that. Their shattered lives being with God and a shattered house. Little Squirt came through the window, didn't have any what the goal was, and wasn't getting the answers he wanted. He made a phone call. Called the girlfriend to bring my gun, someone's going to die. And then he began teeing Amber with a stick. Even in the lights, you saw it. They were in the head. They wouldn't get what he wanted. His girlfriend hadn't showed up. He told her, "You keep them in his back room," while he took that stick, walked up to the front room, and began beating Susan James, demanding, "Where's my gun?" At some point, his girlfriend stepped away from the door, or she had been told by this defendant to remain, keeping his father, Vicksburg, and Amber Niff prisoner in that room. When she stepped away from the door, they closed the open door, dove out the window, and ran away. Interestingly enough, at 8:51, two things happened. The evidence is clear. Little Squirt, his envelope, with the GPS keeping traffic, left this house and returned back where you come from, which is about an 8 to 10 minute walk away, or traveling somehow about 2.5 miles. Or the evidence. Boy, that same time, Amber Neff is at the bus stop, where someone called 911 for her. During that 17 minutes, what crimes did this defendant gross? The judge is going to instruct you as to what a crime is. And she's going to instruct you that the first crime that's charged, count one, is aggravated battery. A person commits the offense of aggravated battery when he or she maliciously causes bodily harm to another by disfiguring her body or a member thereof. Y'all saw Susan James. Y'all saw on the left side of her skull is wide. Now she has to wear a helmet because she actually didn't have any skull on the left side of her. Now her eyes don't track like the rest of us because of the camera device. And you heard her testify that he knocked out multiple teeth during the course of the matter. Seriously, he's also charged with aggravated assault, 2 counts, one against Susan James and one against Amber Neff. The judge will instruct you that aggravated assault is a crime when a person commits the offense of aggravated assault when that person assaults another person with any object, device, or instrument that when used offensively against a person is likely to or actually does result in serious bodily injury. The state must also prove as a material evidence of aggravated assault, as alleged in this case, that the assault was made with an object, device, or instrument that when used offensively against a person is likely to or actually does result in serious bodily injury. A stick, so I'm just going to get, by the way, her instructions are going to be long, but you know. She's further going to instruct you that a stick, if and when used in making an assault upon another person, is not a weapon likely to result in serious bodily injury per se, but may or may not be a weapon likely to result in serious bodily injury depending upon the manner in which it is used and the circumstances of the case. In this case, when the defendant swung that stick hard enough to result in the bruises you saw on Amber Neff's legs, and hard enough to inflict the damage that you saw on Susan James's head. Those are circumstances from which you may or may not infer the serious injury producing character of the instrument in question. Whether or not, under all the circumstances of this case, the stick alleged in this bill of indictment to have been used in making an assault upon the alleged victim did in fact constitute a weapon likely to cause serious bodily injury is a matter to be decided by you based on the evidence of this case. The fourth offense is false imprisonment. A person commits the offense of false imprisonment when, in violation of the personal liberty of another, he arrests, confines, or detains such person without legal authority. Holding a person prisoner in the back room, whether done personally or whether the actual imprisonment was carried out at his direction by his girlfriend, is also prison. He had one for the whole town. He had no authority to threaten them. He had no authority to keep them there, as he said, until somebody finds it so. Thank you. How did this happen? When I was young, I learned a children's song. And one of the lines of the song goes like this: when you choose the very first step on the road, you also choose the last. Susan James' choices led her to this room, that room. Where she was asleep on that cot. And if you look, you can see the stick that the defendant used against his victims. And they described it as being a little bit bigger than a baseball bat. And sure enough, it is. Look at it in relation to the other things in the room, the army cot, etc. This isn't a little piece of wood. This is a great big chunk of wood that he used to beat these two women, one of them nearly to death. In fact, one of them so severely that you heard the testimony of Detective Sajak and of Detective Clayton that they were sure she was gonna die. And that's why homicide did the initial processing of the scene, because they thought this was a homicide. At the point that the police became involved, when Officer Jackson first walked in, gun drawn because he didn't know what he was going to find in there, making sure it was safe for the medical personnel to come in there and treat her. When they found her, they were sure she was gonna die. That's how severely that defendant, Will Squirt, beat his victim. Susan James' choices, and you heard her testify, and she's a heroin addict and has been for a long, long time, since the age of 16. And her heroin addiction put her in this room, in this boarded up house, in the company of other heroin addicts. Will Squirt chose to pick up one of the sticks, that stick, and beat her with it. He used this stick to do that to Susan James. Now, there was testimony from Miss James that she's sure that he used a gun. And when you read count one of the indictment, count one of the indictment is aggravated battery. The state has to prove the case as an indictment. And in count one, we go to the judge read the student's entire. It's alleged that that defendant accomplished the act by striking Susan James. And it doesn't say by what. Because like I said on Tuesday, trials are a lot more like football games than TV shows. Amber Neff testified that she heard the stick that was used against her hitting Susan James. So the aggravated assault is charged as hitting her with the stick. However, the aggravated battery is charged simply as striking. And it doesn't matter what object he used to strike his victim, stick, gun, fists, whatever. The simple fact is that that's what he did to her. And you saw the results even 4 years later here in court, where her face is still and is permanently disfigured because of the striking, the beating that she received at the hands of that man right there. Amber Neff's choices led her to the same house where she had obviously been living for quite some time. The same boarded up, falling down house with the copper wire stripped out of the walls, without water, without power, without gas, living in the most primitive circumstances imaginable. Why? Because her choices led her to that. Heroin addict, prostitute, homeless, and on September the 5th, little squirt set choices resulted in this. These two women didn't choose to be beaten. Yes, their lives were shattered. And their choices led them into the path of Little Squirt, who chose to destroy their bodies, who chose to imprison Amber Neff and his own father, Big Squirt, while he beat Susan James very nearly to death.
This is the first time that you ask for a time advice.
Thank you. Now, the defense counsel will get an opportunity to address you. And then when he's finished, I'll have an opportunity to address you again. Thank you.
John Griffith, please record. Counsel for the state. Hopefully, I'm far enough away from everybody. I did get my 2 shots, so I am vaccinated. First, let me start the same way I did with my opening statement and thank each one of you for this week, this time. We sort of held the pace we expected in the case. We thought we might be a little sooner, but again, I thank you. I know it's not easy. And maybe now, what you're doing here, you now see it's not easy. There's a reason we have trials. There's a reason we have our system of justice, because people disagree and things may be in conflict. And then we need our citizens to make tough decisions, which is what you're going to do. But remember what I mentioned to you on day one. Your role is not to look at a picture and just get emotional and inflamed and want somebody to pay. The role is first and foremost fact finder. You want to find out what happened. What is my evidence? And then from there, start to make your conclusions. I suggest that it is a terrible thing what happened to Miss James. Every time you see a picture of her with her injuries, that's terrible. Don't let anything I say or anything that's happened at this trial make you think that we don't wish the very best for her. But that isn't what drives the question before you. What drives this inquiry is not what her injury was, it's how did it happen, by whose hand or instrument did it happen? How did we get there? And we do it with hard evidence. We don't do it by speculation. We don't twist. You may have heard me say I was an engineer undergrad. Sometimes we'd be in lab and we'd know the answer we're supposed to get. And we do what we call fudging. To get to the answer, we would start to work backwards, so to speak, instead of letting the data, the experiment, the things get us to the answer. And sometimes when we already formed a conclusion, we shape our observations or we shape our opinions. And I encourage you not to do that, not to do that. So first, what I want to do, and hopefully in the beginning, I told you what we would do is give you the evidence. Good and accurate evidence. So the first witness you heard from was the 911 operator. Well, what was significant about Ms. Adams? She played the 911 tape. She herself didn't have anything to really offer. She was just a custodian of rights. But you got to hear the 911 tape. And you heard two individuals. You heard an unidentified lady who made the call. And you also heard Amber Neff. And you remember that part that got played a couple times where Amber Neff was being asked, well, who did this? Well, you have it's not Mr. White's here to mind you. Sure it is. What did she say? I suggested what she said was, I don't know. And then remember I tried to ask her about it. What did she say? Well, I couldn't. How do you describe it right now? I thought that was strange. Remember I said, I'm like each other. Where's that? If you would just beat by somebody, even if you didn't do that, wouldn't you just immediately say their name? Wouldn't you immediately describe them? Well, let's pause on that momentarily. The other very significant thing is 8:51. That's the time of the 911 call. So you know in front of you, I think it's undisputed that by 8:51, 911 is being called. Everything in that house at this point is essentially. Well, I'm sorry, what about the last one? Amber didn't stick around. She was with someone, she was safe. She didn't stick around and find out who somebody was. Or that. So then you have Officer Jackson, who was the first officer on the scene. Remember, he said the front door was locked, so he ended up kicking it in. He said the EMTs were there, right? But they had no mind to lock the door and they wanted to make sure it was safe. He kicked the door in, and the only person they saw through the window, and then hopefully when they were inside, was Susan. And remember at the end of his testimony, he said he developed 2 suspects. Not 1, 2. Big squirrel, little squirrel. That's his testimony. So, he also said there were some pieces of wood on the floor. He did say there was some blood on the floor. And he's a sort of the first responding officer. He wouldn't be responsible for testing for that. He did his role with this investigation. No issues to take with Officer Jackson, and he definitely doesn't have any biases. He's basically just giving you information. Then Amber, well, she told you she was hit on the legs, back of the head or this side of it. She even told you that one of the times she was hit, she was sitting on the couch with Mike. Now, some of the things you can see I highlighted, which I suggest to you are the most significant things you're going to pick up from that. She said she cannot describe or identify the sticks that she was hit with. Remember, I asked you, well, what color? I can't tell. What size? I can't tell. What shape? I can't tell. And I'm sure someone out there realized she never identified Stacy's stick from the farm. She never once said, those are the sticks I was hit with. Or it was a stick that looked like this. Or it was a piece of this stick. Amber never, undisputed, never identified the stick. Well, what else was significant from that testimony? She told you that Susan was already asleep. And we're going to come back to that. Well, she also said what? It was through her that you found out that another person, remember, even in the beginning, I gave you sort of a list of people that were there. Lisa. Lisa is the lady you told. Lisa. Then Lisa said, hey, Susan was helping Vince work to try to find the drugs on the kitchen floor. Well, even Susan came in and said, what? I had a flashlight, so we were looking for it. Okay? So I would suggest we can comfortably conclude that prior to Amber's arrival, Susan was already there. She was already there with Vince's work. There was already some issue with drugs coming up missing at that time. That's it. I would suggest a fair conclusion. Now, she also, very important, said she never saw anyone hitting Susan. Remember, Amber said she was in a different room. She said she heard what sounded like hits, but she did not actually see who was hitting Susan. Well, why does it matter? Well, even by her own testimony at this point, Amber puts a stick in 2 different hands. She puts one stick in little squirts. But if you remember, she also put two big squirts. Now she says, oh, well, that was just because he didn't want to get hit. But what is that still telling you? You now have in the first 3 witnesses an officer who has 2 suspects, big and little. And now even your first victim telling you there were sticks in the hands of Big Squirt and Little Squirt. And when she heard something being hit, she couldn't tell you who was swinging the stick. Or even if it was a stick. only that she heard it sound. I would argue we'll discuss, but circumstantial evidence. Now, she also, a significant time, mentions that she spoke to Susan's mom. Remember, I asked her if you had a chance to speak to Susan. Susan was still out. Susan the baby was still sort of out of sorts. And her mom had been reaching out. Her mom was very pregnant, but also spoke to Amber. So mom has a role in this because as soon as Susan the baby wakes up, mom's having a conversation. And you heard this from Susan and Detective Rowe. What did Susan say? Well, my mom thought that based on my injuries, it seemed like I must have been hit by me. That came from mom. It didn't come from evidence. It didn't come from anything at the crime scene. It came from mom. And I would suggest that if Susan is not aware of what happened after she claims she saw Amber, she filled the blank in with what she's hearing from mom that you were hit with none, and what she's hearing from mom via Amber. It was work. In other words, it all seems to flow from Amber. Now, somebody may remember that I started to ask Amber about the time. Remember, I said, well, how long would you say it was from the time you got there and little Squirt starts messing with you? Remember, she said she gets there, little Squirt comes into the time, and then she says, little Squirt starts to hit her, starts to ask questions, they start searching, they sit on the couch, she gets hit again, a variety of things. Remember, she said it was about 30 minutes from the time I got there to the time I went into the back room. Then I asked her, well, how long would you say you were in the back room? She said, 5 minutes. Well, once you leave and you get to the corner where you make the 911 call, about how long did that take? What did Amber say? 5 minutes. And then how long actually you make the call once you come in contact with me? She's going to time. Okay. So if we start to work backwards from our timeline, we know that if the call is made at 2:51, we can start to estimate that if Amber is telling you the timeline of things, what her stored timeline is. And we're talking about what, 41 minutes? So that means everyone would have been there about 8:10, 8:11, for it to all time out. Now, here are some of the things, and I sort of laid out that 8:11 is a reasonable conclusion for Amber to be accurate and telling the truth. 8:11 would have to be the number plus or minus, because again, 8:51 is not a phone call, 8:49, she arrives at the corner, the time for escaping out of the house and getting to the corner. So I'm creating this timeline not out of argument, but out of her testimony. Now, I suggest that you have something that is absolutely unbiased. It is pure data, the GPS. And the GPS record is clear that it was not at that location in the. So, before we get into the conflicts of testimony of witnesses, you have pure objective data that says that doesn't matter, right? Their testimony doesn't make sense because the GPS isn't even there to allow 34 for the absolute sense in terms of being in the vicinity. So there's a lot of time that doesn't make sense. And I suggest when struggling on an important decision, start from your objective data that can't be twisted by the defense or by the state. Now, other important things. Amber never saw Susan being here. I covered that, but she also never heard Susan speaking. Well, why does that matter? You heard Susan yesterday tell you, oh, I started to offer him money that I had. Remember $1,300 that she all of a sudden had that no one had heard about in 2017 or 19, but now it's coming up in what, 2021? But you remember Susan told you, oh, I was fighting him, I was kicking him, I was scratching him. He was telling me I'm gonna die in the hospital. I was offering him the money. Well, if you're going to believe anything from Amber, then you can't disregard the fact that she said she never heard Susan speak. And the only thing she heard in terms of Little's heart was where is she? And she just heard sounds, and she said she heard moans. That's what Amber said. So Amber is in complete conflict with what you just heard Susan. Now, Amber also said, hey, I was never hit with a gun, never saw it. So that also creates conflict because Susan is telling you, I saw Amber getting pistol whipped, hit with a gun, and I knew I was next. There was never a gun. There's no evidence of a gun. And Amber tells you there's no evidence of a gun. And in fact, here is one of the pictures you saw of Amber. I suggest you two things. This picture does not show any injury consistent with being hit with a gun. It is not consistent with any injury of being hit with a stick. There's nothing there. Now, you don't have to put my arms. You have your own eyes, you come to your own conclusions. But I would suggest, certainly, there is nothing there to suggest a gun. So let's get to something else she mentioned. She said she was hit in either her left jaw or her right jaw. Let's go over this. This is 2 days later. Remember, she suggested to you, stated to you, that she was hit on the side of her head so hard that she lost 5 teeth. I suggest to you, there is not a single indication looking at that side of her face that she was hit with anything. Anything. But let's look at the other side. So that's one thing. Here's the other side. Same conclusion. I would suggest to you, just common sense, basic life experience, if you got hit with a hard metal gun upside your face to the point of losing 5 teeth, there's going to be a mark. She is white, pale skinned. You saw bruises on other parts of her body, on her legs. Why would there not be something on her cheek? And I understand that may be tough. But to just start pulling your teeth out and never once go get medical care. Remember she told you that? She did not get medical care for any of the injuries. Any of them. She just kept pulling her teeth out, she said. I will submit to you. If her teeth were coming out, that's a function of neurostic monsters of addiction. Whether it's meth, heroin, you can observe her. You know she is an addict. You know she was prostituting in 2017, and you know she was just convicted of felony prostitution in Texas. So what you were seeing is not a person that has been beaten and looks this way, a person that has made life choices, and that's how she looks. But we can't imagine injuries that aren't there just because we want to convince you of something. The facts are the facts. Now, while I'm here, I'm going to show you what you were shown. Six. We'll say something that is rare that everybody doesn't say in the case. We didn't want these things. We know. And you know why? Because it's never told you those are states. And Susan James never identified these states. Susan James never even said she got hit on it until yesterday. But these states aren't even evidence to show you. You don't get to look at them. You don't get to, for yourself, size them up. But nerd as I am, said, well, maybe there's context that I can get. Well, I see a law and little something. If I use them as a bit of a measure of size, those sticks are quite small. They're not a bigger than baseball kind of stick. They're small sticks, and look at maybe an inch, not a 2x4 or a 2x3. You ain't gonna frame a wall with that. You might make a deck rail post, maybe, with something about that size, but that ain't no framing wood. You ain't gonna build a wall with it. But here's the thing, the reason I said you can ignore this, you don't have it, you can't look at it, examine it. It wasn't collected as far as you know. And what else did you get from the protected plate? Wasn't tested, so you don't know if there's blood on it. The state is going to suggest if you look real close, isn't that blood? You don't have it. It was never tested. Well, if we did have it, if it was tested, we could have tested this for fingerprints. Could it have been tested for DNA? Then how? His fingerprints on it. His DNA is on it. Game on. Or, maybe more importantly, Big Squirt's DNA is on it. Big Squirt's fingerprints on it. Game on. Clear. Nothing.
Wouldn't you think in a case, especially you think this person's going to die, homicide detectives, aren't they the the best? Aren't they going to bag it all, seize everything? Well, let's not forget what Officer Jackson told you. When they left for the night, it wasn't even secured. And homicide came a day later, 2 days later, maybe you have it in your notes. So, whenever they point to you these sticks, you should be asking yourself, what does that have to do with the price of tea in China? How is that relevant to anything in this case? This has, I don't know if these are the sticks that I should be considering, but they want me to believe it is and believe that, oh, there's a nail, so that means if there's a scratch on this nail or a puncture, it must have come from one of these sticks. You know what that's called? Good old-fashioned speculation. You don't convict people on speculation. So, all right, I digressed a little, but let's get back on. I'll get back on task. The GPS. You have the GPS records. I suggest to you that's an anchor of your analysis. The standard even in there, opening of their closed, talked about the GPS, the ankle monitor. I suggest it is because of these records that acquitting my client becomes simple. If you look at page 19, you will see in 834, the most that Mr. Suss could say, that's sort of his expertise, is he was in the vicinity. And actually at that point was across the street. Then at 8:35, he said, well, he's in the vicinity. He might be in, might be out. You can't really tell. 8:40, same response. 8:45, maybe in the house. 8:45. Now, I'm going to stretch with you. Let's say 8:45 is when he actually enters the house, then he would have had to accomplish everything in a minute. Because remember, it takes Amber 5 minutes to get to the corner and a minute to call. So he would have had to do everything he's accused of doing in a minute. So let's stretch it even farther. How about 8:34? Well, now we're still, 8 minutes? He's doing everything he's accused of. Yelling, screaming, searching, hitting Amber, calling somebody, asking for guns, hitting some more, calling his girlfriend, waiting for the girlfriend to get here, and everything is all in 8 minutes. That ain't possible. It's just not possible to do all that. So, let's show you a little bit of a couple. So, go ahead. And let's look at it. I'm not sure if you saw it. This is the report we're talking about. So let's go to 19. All right. Well, at page 16, at 8:31, you see right in here is the actual location, the blue pin, the blue flag. The red flag is the GPS. Okay, well, let's get a little bit closer in time. Well, here we are at 8:33, completely across the street. At 8:34, page 19, you see it appears to be in the yard outside the house. But as Officer Sluss said, I can't tell you exactly. I can only tell you he's in the vicinity. He may be outside, he may have gone inside, but you can't really tell. But I suggest if we look at how these flags are, especially if the state is contending that somehow the GPS is evidence of guilt, then we say, well, wait, these are not suggesting at page 19 that he is inside. Well, on page 20, at 8:35, he still is not necessarily inside the house, I would suppose. But I would say for our analysis, even if he is, there's not going to be enough time to do all the things that they're trying to say he's doing. But we keep going. Page 21, the flags are still apart. Do you remember there was that discussion where either he nor I could really say, well, if it's 0.00001, doesn't that suggest 31, 36 feet away? He couldn't confirm it, so we don't know. So we're stuck with just what we have. What we have is two flags that clearly are separate. And then we go to page 22. At 8:45, there appears to be some overlap. So that's why I suggested, well, maybe at 8:45, he's in the house. But again, remember, if the 911 call happens at 8:51, that's 6 minutes later. That means everything he did, which remember, has to include meeting Amber, then searching, talking to his dad, making a phone call, meeting Amber on the couch with Mike, making another phone call, getting Quanah to come over, all in 6 minutes. You don't get to this dispense with all that because you can't make it fit. So, and here at 8:50, the flags are again apart. This is the data. So, what I did was after sort of breaking out those pages for you, and it's all in evidence, so you can look at it. You look at it up close. So you get this, let me say it. It's not me, it's your evidence. I'm just pointing out to you what is in evidence. But I want to remind you, where he has to come into the house, search for dad, search for drugs, question Amber, beat Amber, search for drugs, beat Amber next slide, find Susan, beat Susan, and then get out of the house. And I said, let's just put a range, 5 to 10 minutes. He's doing all that. And I think I forgot to wait for Quanah to get there. Because remember, you can't have people in the back room if Quanah's not there. So you can't dispense of the whole Quanah or calling Quanah and waiting for her to come. So, what is more likely based on that? I suggest, ladies and gentlemen, it will make more sense that before little Spike even arrives, that Susan had been injured. It would explain how she's not making sound while Amber's moving. It would explain that while Amber, Mike, Lisa, everyone else is sort of awake and doing something, Susan isn't. Well, what do we know from Susan's testimony? She was finishing a 36-hour binge. Now, I know somebody caught that, wasn't she at the SEC thing? Then later on, she said, no, I've been in the bluff for 36 hours. Somebody caught that. She impeached herself. And I would suggest that hopefully y'all caught that. So if she's been in the bluff for 36 hours, she told you she took what, $1,500 of client money. And she said she had to get high, what, every 3 to 4 hours. That's not me. She told you this. Because what did she say? If she doesn't get more stuff within 3 to 4 hours, she what? Detoxes. She starts to have problems. So you're going to believe that she still had $1,500 of her employer/boyfriend's money after 36 hours in the club. Let's see, 36 divided by 4 hours, that's 9. Not sure how much heroin costs, but 9 times heroin, I guess, re-ups. She actually told me she spent a couple $100 earlier that day. Down at the pain location. But I digress. Once again, folks, why is it more likely, based on the timeline, that Susan was already injured? Because she tells you she gets there at 3 or 4 in the morning. Well, and she also tells you when she was out. So she's out of dope, so she goes to her friend. She gets there at 3, 4 in the morning, and then what does she say? Oh, Big Squirt is there. Now, Big Squirt don't live there. There's no evidence of that. Big Squirt's down on Pain. That's where she bought, right? She said, no, they're one and the same. I spend money with them. They're Pain. Well, if all of a sudden he's meeting her there at 3, 4 in the morning, maybe she said she had some money, needed to re-up. You know why? She's at that 3, 4 hours mark. And maybe he is tore up. Maybe he's drunk. Or maybe he's just parked his head into the house with no power. But if he loses his dope, what else do you know from Susan? She's the one person that had a flashlight. Now you think Susan, who will steal cars from her employer and wife, who will do the things she does when she's going through. Again, feel versus any person to addiction. But this is that monster. This is addiction. Oh, I'm sorry. Feel for Susan. But this is that monster. This is addiction. You think if she sees his dough on the floor and he don't realize it, he don't see it at the same time, that's called let me just pocket it up. And I don't think it's here, I'm gonna go to sleep. Or you think she's gonna think, here is your dough that I so badly need, but I'm out of money. I suggest it is just as plausible that that dope didn't go missing. Seems like everyone said it was missing from Big Squirt. But if she did find the dope and did shoot up, couldn't it explain why she was knocked out by the time Amber gets there? Not because she was going through it, but because she was in Wonderland. Because she had dope at the expense of Big Squirt. And if it happened that way, who's the person that would have been pissed off? Big Squirt. Not Little Squirt. Now, someone right now would be like, come on, he's going there, spin it. No. I'm suggesting to you that based on the GPS, based on the timelines, this is a more likely scenario than all of a sudden, Little Squirt is just gonna pop up out of nowhere and go crazy. But let's keep going. Well, She wants to tell you, I'm going to spend another 1,300, and then for the first time, 17, 19, or 2 months ago, says, oh, I had $1,300 taken from him. And I offered him $1,300 to stop beating. That's just straight up not true. It's not true. Now, so the only two people from 3 a.m. to about 7 or 8 a.m., let me shoot back just a little, that we know were in that house is Big Squirt, Little Squirt, and maybe Lisa was in the background. Now, let's talk about Big Squirt a little bit. You've been hearing Big Squirt. You have no evidence that he ever had 2 black eyes because his son beat him up. That's coming from Amber and Susan. People that I'm suggesting to you cannot believe. But if he did have pictures, Detective Clark didn't even have them. No one took the time to say, hey, Big Squirt is a suspect according to Officer Jackson. He was also there. He also had a stick. It was his goat. We need to talk to him. And if there's a black eye, take a picture. You don't have that. You don't have any evidence that Big Squirt was afraid of Little Squirt. You kept hearing them say it. Just because someone says something, don't make it true. I paused about doing the politics and all this and that. I digress. You can keep saying something over and over and over and over and over. It doesn't make it true. It doesn't. I don't care what side. Black, white, Democrat, Republican. It doesn't matter. The truth is the truth. A lie is a lie. How many times you read? So, we know Big Squirt sold drugs to Amber, or she told me several times. We know Susan said she had been buying drugs earlier on Payne Street. So, like I said, maybe he came over there thinking he was going to sell her some more, and the okie doke happened in the kitchen. Now, what else do you know? Big Squirt must have called Little Squirt. Now, common sense. You lost something. Let's say your dad, your mom, whoever is going to be upset. The last person you're going to call is them. That's a common sense thing. Common sense says if Big Squirt is afraid of Little Squirt, the last person he's going to call is Little Squirt. But how do we know he did? Well, according to Susan, her phone wasn't working. No one else seemed to have a phone, so it must have been Big Squirt's phone. Reasonable deduction. No one else had a reason to call Little Squirt. Certainly Amber and Susan didn't have a reason, did they? Hey, we took you to that stuff. Why don't you come over here and handle this? Come on, that ain't gonna happen. So, Big Squirt would have called him, and how do you know? Because when Little Squirt got there, what did Amber say? The first thing he's talking about, where's my dad? Where's my goat? She twisted it a little, but it still says what? Little Squirt already knew. Somebody had to tell him. It had to have been Big Squirt. Okay. And if Big Squirt is the ones whose drugs are missing, he's the one that got taken advantage of. I would suggest to you, he's your prime suspect. The heavy set, Big Squirt, as opposed to the Little Squirt. Now, let's clean up some other things. If Lisa and Lucy, that's remember Lisa, the other lady, and her dog Lucy, already in the back room. So when Quanda arrives and supposedly makes Amber get in the back room and Big Squirt get in the back room, Quanda, who's what, shorter than 5'5", 100 pounds wet, you got that from Susan, is gonna stand at the door and keep them all hostage. Does common sense, does that make any sense, logical, common, or otherwise? And I'm sorry, Big Squirt got a big stick in his hand, according to Amber. But he's gonna be like, yeah, I know you're my customer, but yeah, or you're my boy's girl, but I'm gonna go ahead and let you just keep me in. Come on. And look at the pictures. I don't know, but I'll throw out a open question. I don't know the answers to it. Look at the picture. Is there even a door there? Remember, Amber said, oh, he locked the door so they couldn't come in, and that's how we escaped. Because I just don't remember seeing any doors, but you looked. I'm telling you, I don't remember. I know the door to where Susan was, there is no door. But I don't recall a door to the back room either. But look, because if there isn't, that's another reason to say, oh, that's hogwash. All right. And Detective Clayton told you what? Quanda was not arrested. So you mean to tell me that this girl came over, forced these people into a room so her boyfriend could beat the hell out of them, and she ain't getting charged? Really? Does that make sense to you? All right. This is the section I just said, never a gun. Hopefully you already got this. Amber never saw a gun. Amber never hit with a gun. I already told you how before Susan made her statement, her mom spoke with Amber, plus mom had already told Susan, the victim, about how it looked to her. I mean, the point is, I'll just hit the quick points again. Let's not forget, Susan has always said this was with a gun. She said it in 2017. So let's say you're in a group of people that say, well, she was under the influence in 2017. Okay, in 2019, when she filed a lawsuit, how about that? By then, certainly, wouldn't she have come to her senses and said, oh, I got hit with a stick? No. Still says gun, but it's worse. She says, he dragged me by my hair into the house at gunpoint and pistol whipped me. Where did that come from? That certainly wasn't 2017. And then 2 months ago, she filed another lawsuit that said what? Oh, I was also armed robbery. Her story evolves. Now, a suggestion for those who say, well, why would she say this? Why would she believe it? She seemed like she believed it. She may believe it now. Because sometimes if you say it over and over and we don't have any medical testimony, we don't know if now for her it's cemented in her mind that this is what it is. Because some people with mental health challenges, their reality may not be the realities, but for them, it's real. I suggest if you think she seemed convinced of what she's saying, that doesn't make it real. It just doesn't. There was no gun. No gun. So, what else? Nobody ever heard her say the words, whether at the time, Amber, Detective Clayton, anywhere, this whole stuff. He pointed at me and said I'm gonna die at the hospital. He strangled me. He hit me with a stick. He hit me with a 2x3. None of that. I offered him $1,300. None of that. And I apologize to y'all that I got firm with her in my questioning Because I kept trying to get to the end of the exam and she kept saying something new, something more. All of this stuff is new. All right. I think I covered the lawsuits. I covered all this stuff. I mean, here's the thing. No matter what she said, she even didn't identify those sticks. She never once said, those are the sticks that I was hitting. And again, we don't have the sticks. We also don't have, a whole lot of information that would have helped. Look at Detective Clayton. Nice guy. Does his job. But here's some things that didn't get done. There were no tests done on those sticks. In fact, it's a big question whether they were collected. So you don't have a stick. Well, he told you lab tests done on fingernail shavings and other swabs for a rape kit. None of them came back, to Leon Jones. He doesn't have any reports that say Leon Jones is the donor. He doesn't have any fingerprints. If he was concerned about the lineup, remember yesterday, then why not go give her another lineup? But he didn't. He did no additional interviews with Miss James to say, hey, I know you called out a few names when you were looking at the lineup. Let's go back over that. Or I know before you said you didn't remember anything. So I wanted to follow up. Are you feeling better now? Are you feeling a little more clear and lucid? Let's go back through this. No. He didn't arrest Wanda. He never interviewed Mike or Lisa. But he said Amber seemed to be in touch with him. Why would you not, Amber or Detective Clayton, trying to follow through, get a hold of these folks? Why not get a hold of Big Squirt? And he told you, no, she never said anything about kicking. She never said anything about offering money or being strangled or that he said she would die in the hospital. Nothing. And what else do you not have? Y'all don't have any medical records. None. So if you start to say, well, she says it was a gun, she says it was a stick, maybe medical records would shed light on it. You don't have any. And why does it matter? Because in this indictment, they must be for the aggravated assault count. Remember, we got 4 counts. The aggravated assault counts mean it has to be done with a stick. And the minute you say, I don't know that, I don't even have the sticks to look at to say that this is what you were hit with. You should say to yourself, I must acquit. The evidence is not there. Let me shift to another thing. And Your Honor, may I ask for a time check?
Sure. Just, you have about 10 minutes.
10 minutes. Oh. So, the judge is going to talk to you about the law, so I'm not going to go a whole lot. But just again, summarizing, the timeline doesn't work. The GPS records point to acquitting my client, not convicting. Okay, again, all the different things he would have had to do in that timeline I list here. But the absence, whenever you say, I wish I had lab reports telling me if he ever handled the stick, whether her blood's on this stick, whether this is even the stick. I wish I had, the minute that statement comes out, not guilty. When you say, I wish they had followed up and interviewed her again, not guilty. I wish they had talked to Lisa, not guilty. I wish they had talked to all these different people, not guilty. I wish I had medical records, not guilty. Why didn't they talk to Miss Sasser, Burkett? Remember? That's what the homicide detective. He talked to those folks, but there was no follow-up. The coroner lady, no follow-up. Then, so there's absence of evidence, there's conflict of evidence, because Amber and Susan are completely opposed. They are not consistent to each other at all. Stick versus gun, asleep versus awake, there's no way to reconcile them. The lawsuits cannot be reconciled in any form or fashion, and you should just ignore this stuff about I was hitting and kicking and being strangled and offering money. I think you know that's a person who's doing everything they can to convict the person they think did it. That doesn't mean he's the one who did it. She really doesn't know. That was what she said in 2017, before she had time to think about it and try to file lawsuits. All right, presumption of innocence. Judge will read to you the entirety of the law. I just want to point out a few aspects of it, and that is this. A doubt based upon common sense and reason doesn't mean a vague or arbitrary doubt, but a doubt for which reason can be given arising from consideration of the evidence, a lack of evidence, conflict with evidence. Those are the things I just went over with you. And she'll also read to you what grave suspicion. Let's say you might say, I think he did it, but I don't see the evidence. That's grave suspicion. The law says it's not guilty. You have to find proof beyond a reasonable doubt, each and every element of the crime. That's why I keep telling you, it has to be a stick. Now, the state on count one says, well, it could be a gun, it could be a stick. Well, if you're going to now say it's a gun and there's no other evidence of gun, then shouldn't it then be a medical record or something to say this is what likely caused this injury? But I suggest you don't have to go that deep. Because when you look at the timeline, you look at the evidence, lack of evidence, conflict of evidence, the minute you say, I can't say he's the one that did this, that's game over. You don't have to get to stick or gun. You don't have to get to, well, her injuries. You don't have to get to any of that. The only other thing you have to decide is, do I think Quanda, at his direction, kept them hostage? Well, if he's not the one that did it, then why would he be the one to false imprison them? So that's a no-brainer. The point is, there's no evidence against my client, Mr. Jones, that is of greater weight or more indicative of guilt than anything else you have against Pittsburgh. And because no one saw my client or anyone else actually hit Mr. Jones, I would submit it's for you to decide what is direct evidence, what is circumstantial evidence. And the law of circumstantial evidence the court will give you is what? Any hypothesis of innocence. The state has to overcome any hypothesis that it ain't him. You have to eliminate it being big sport, I suggest. And if you can't, you must agree. That's why you can't be emotional. You can't let sympathy, because you have to let the facts drive. The last two areas of law that I just wanted to point out, and I did, I think, have a little list here. Mere presence. Just because Little Squirt was there doesn't make him guilty of the thing. Just because he's associated with Big Squirt doesn't make him guilty of a thing. You have to be doing something to be part of a crime. I suggest that that's what the judge will tell you. So I'm gonna sit down, but I wholeheartedly suggest that the entirety of this case is built on the testimony of the two ladies that the state wants you to feel sorry for. No, it is sorrowful that they've made these decisions because they're struggling with addiction. But we don't forgive it so that we're now going to imagine they're credible. That their addiction also hasn't shown itself in a way that has falsely accused this man. You don't, someone I know took note. How long was it? 3-4 months later, after this incident, she was back, Susan was back in the boat. Becky in the boat, right back at you. Becky was back already, committing crimes and buying dope right back in the same area. They're not worthy of belief, not because they're not good people, I'm sure they are, but because they're people with addictions that make them do things. They are people with addictions, and that addiction makes them do things that aren't right. So, on aggravated battery, not guilty. Aggravated assault against Susan, not guilty. Aggravated assault against Amber, not guilty. False imprisonment, not guilty. Not because it feels good, whatever your verdict is, it's because it's the right verdict based on the evidence. A lack of evidence, the conflict of evidence. That's why it's the right verdict. Thank you.
Thank you, Mr. Wright. Mr. White?
Thank you, Your Honor. Ooh, no, I didn't, I apologize.
Want me to clean that screen?
It's okay, I'll bring it to you. There you go.
I'm sorry.
No problem, sir. Thank you. My learned colleague and I agree on this. If we are to reach a just verdict, a verdict that speaks the truth, and the judge will instruct you that that is your job, your duty as jurors is to honestly seek the truth. And if you are to find the truth, you must begin with the objective data. And the easiest place to find the objective data is in State's Exhibit 44, no, 43, State's Exhibit 43, the report from Detective Sluss. And Detective Sluss told us yesterday, and his report tells us still, exactly within feet, he said, of where the defendant was during the time frame from the data that was available because the defendant was wearing a GPS ankle monitor. And Detective Sluss told us he uses Google Earth Pro. Why? Because it gives really good close-ups of the Earth. In fact, when you look at it, it gives you the house. The blue flag, Detective Slush testified yesterday, is in the geographical center of the lot. That's not where the house is. Google Earth does us the favor of giving us the house in a gray outline. It doesn't outline the rooms within the house, but it does give us the house. And so let's look at the objective data. At 08:34 a.m. This defendant is within the gray outline of the house. There he is, close to the geographic center of the house. What do we know from the photographs? Unfortunately, what we don't know from the photographs are what the back bedrooms look like because, well, Officer Jackson told us when we took pictures back there. Detective Sajak told us only photos we have are of the living room and that front bedroom. The only reliable evidence we have about that back bedroom is the description given us by the people who were there. We'll go into that later. But what we do know is that the geographic center of the house is the living room. And there he is, exactly where the witnesses said he would be, exactly at 8:34. At 8:35, 1 minute later, he's not the geographic center of the lot, which is the blue flag, but he is within the gray outline of the house. When he came in, the testimony of Amber Neff is what? He came in, where's my dad? Where's my dad? He's looking for him, and he's still in the geographic center of the house at 8:35. At 8:40, which is 4 minutes later, we know exactly where it is. He's beating Susan James in the front bedroom. Why? Because the gray outline of the house puts the defendant in that front right corner, which Officer Jackson pointed out is the front bedroom of the house where the armed cop is. And now we're going to do a little bit because it's objective data, and objective data is important. But I'm tired, and it's been 13 seconds. "17 minutes is an eternity in a situation like this. It's not that it's impossible that this crime lasted 17 minutes. It's that it's improbable that it was actually that long. At 8:45, which is 5 minutes later, now the defendant has moved either to the back of the house, or after being in the house for 11 minutes, has actually exited the house and is in the area of the back of the house. Why is this important? Because about this time is when we know from the objective data that Big Squirt, the defendant's father, and Amber Neff escaped out the back window and began making their way to the bus stop, where finally 911 would be called. Looking at the objective data, at 8:50, the defendant is back in the geographic center of the house. By this time, there are only two people in the house. Maybe three. There's Susan James, who we know the defendant was beating on for at least 4 minutes. Remember how long 13 seconds was? She took a beating like that for not 13 seconds, but for 20 times that long. And finally, at 8:51, we see that the defendant has exited the house and is on his way back up the hill. Bryant Street from where he came. To Bryant Street from where he came. Yeah, he was in the house. And the objective data puts him in the house. And you'll have this data back there with you. You'll have the report back there with you. You'll be able to see exactly where in the house that defendant was when he beat Amber Neff and when he beat Susan James. The objective data demands, no matter how finely my esteemed colleague and his engineering degree wants to cut it, the data can't be fudged. This isn't a fudge your data kind of day. This is a data demands a finding of guilty of all 4 counts case. Once we've looked at the objective data and we've established beyond a reasonable doubt that the defendant is where we think he is at the time that we think he's there, maybe I don't know how to close this. So we'll just do that. we have the statement of Miss Amber Beth. Remember, what we have here is while APD is trying to figure out which division is going to be investigating, well, is it a homicide? No, because the victim, Miss James, isn't going to die. So homicide not investigating. Well, is it a sex crime? Well, there's no real evidence of a sex crime, so all of that search warrant and all of that, maybe it's never tested. Why? This isn't a sex crime. So finally, it lands in the lap of poor Detective Lee on September the 7th. And at about 9:40 a.m. on September 7th, who should wander into Detective Clayton's office? According to his testimony, unannounced, uninvited, and unexpected, but Amber Neff. Contrary to what the defense counsel would have you believe, she didn't disappear. She didn't just abandon and cut and run. No. She shows up at the police department. Remember, this is a heroin addict who's been living in the most primitive of circumstances imaginable for who knows how long. This is a prostitute who has the felony prostitution conviction to prove it. This is probably the least friendly person toward a police officer imaginable. She doesn't want to have a police officer in her business. None of her business, her entire life is illegal. Everything about her life is illegal. Not based on where she came from, but based on the decisions she has made when under the influence of what my learned colleague correctly called that monster addiction. And yeah, it's got her right in its jaws. But she comes right up to the police department and says this. On Tuesday morning, I stopped at 592 James P. Brawley. Not even 2 minutes later, I heard a loud thud in the front room and went to see what it was. At this point, why is she in the police station? And once she's there, what motive does she have to lie? Little Squirt was coming through the front window screaming, "Where is his dad?" Remember, you have to come either through the front window or the back door of this house because the front door is locked and will remain locked and impassable until Officer Jackson kicked it in order to gain access. After he saw Susan James lying on the floor in that front bedroom, in a pool of her own blood. And remember his testimony? At that point, he thought she was already dead. And so he leads Brady emergency personnel in, and lo and behold, she's not, by some miracle. Where is his dad? Let's talk for a minute about what the defense counsel would have you delve into this world that he's created inside of his own argument. Let's shed the candle of truth. Let's carry the candle of truth into that darkness. If the fantasy were real, he wouldn't be screaming, "Where is my dad?" Because if his dad calls him, he knows. So the fantasy, if his dad called him, he knows. The fantasy isn't real. The fantasy is desperation. At this point, the defendant is a desperate man. Desperate enough to blame his own father for the crimes he committed. Desperate enough to blame his own father for the beatings he inflicted on his victim. So Amber continues, "I told him, I don't know, I just got here. We went to look and Big Squirt, his dad, was asleep in the back room on one of the beds, and my friend Lisa and her dog was sleeping on the other bed. Little Squirt woke him up and was asking where his dope was. Little Squirt, the defendant, woke his father up, "Where's my dope?" If they're in business together, which is both what Amber Neff and Susan James said, that seems a perfectly reasonable question. Where's my dope? Big Squirt checked his pockets. Said, "I don't know. It's gone. Somebody must have got it because he was drunk last night and passed out. I went out to the living room." This is Amber. "I went out to the living room where my friend Mike was getting ready to leave for work. Little Squirt came out and said for both of us to sit down because nobody's going anywhere till his dope was found." Does that sound like the fantasy the defendant has tried to create for you? No, this is reality. This is where the objective evidence has taken us. Right here, these are the objective facts. The objective facts are not the vague, arbitrary, fantasy, I wish I had more stuff world that the defendant would try and lead you into. No, it's not that counts. It's the objective evidence that counts. He got on the phone. At this point, from the objective evidence, we know where he is. Because why? We're 2, maybe 3 minutes in, and the objective evidence puts Little Squirt in the geographic center of the house, which is exactly where Amber puts him, in the living room with Mike and Amber sitting there, and him demanding, "Nobody's leaving until I find my dope." And then he got on the phone and made a call and told somebody, "Bring up some guns or bring up some pistols." He had a big stick in his hand and asked me where his dope was. And unfortunately, Amber never is able to describe the stick any better than that. I said, "I don't know, I just got here." He then hit me on my left leg. I started crying, pleading with him to stop. He hit me again on my left leg. What's the objective evidence that we have? On her left leg, 2 days later, bruise after bruise after bruise on her left leg. What's the objective evidence? The objective evidence is in the photographs of her left leg. The objective evidence is in the GPS that shows this defendant in the geographic center of the house, while Amber Neff, 2 days later, is explaining exactly what the defendant was doing. After she voluntarily did the least likely thing that a heroin addict and prostitute would do, and that is came voluntarily to the police without them expecting her, without them inviting her, without them asking her, without them knowing anything about her. When I tried to stand up, he hit me on the left side of my head. And then he goes into get up. I'm not going to read it all verbatim. Accuses her of it being his fault, her fault, because she's friends with his daddy. And if she weren't, he wouldn't be there. As I went to stand up again, he hit me again on my leg. 1, 2, 3 smacks in the leg, 1 to the side of the head. I got up and limped into the back room with Lisa and Big Squirt. We don't know what's going to happen to Mike, but he got out of there somehow. And now we have Lisa, Big Squirt, and Amber in that back room. He got on the phone and called his girlfriend and called his girlfriend and told her to come up there when his GF Quana, I'm assuming that means girlfriend, but we'll just go with GF, that's what she wrote, got there. He told her to stand at the door and not let us out. We don't know how long that was that he was there. But we know that by 8:40, which is 6 minutes in, he had moved into the front bedroom, where he spends the next at least the next 4 minutes beating on Susan James. Not hitting her 4 times, hitting her for 4 minutes. Lisa told him that night Becky, Mari, came into the room and said that Big Squirt was passed out on the kitchen floor and his dope was laying out. We could speculate as to what happened to that dope that was laying out on the floor. And I don't think that's necessarily either relevant or helpful, no matter how much the invitation of the defense is to speculate on what happened to that dope. Little Squirt went into the front room. Remember, it's Lisa now, who we don't know a whole lot about, other than that she's living in that house. And so we could speculate about Lisa, and certainly we've been invited to, but we won't, because that doesn't help, because that's not evidence. And as my learned colleague reminded you, speculation, even when invited by the defense, is not evidence. But Lisa has told him, hey, Susan was with Big Squirt and the dope was out. Little Squirt went into the front room, we know when, at 8:40, where Becky, which is how they refer to Susan James, was asleep on the army cot, and started screaming, "Where's my dope?" Expletive, and began beating her. I could hear the thuds from the stick hitting her body. The defense somehow would remind us, or would have us believe, that our only effective sense is sight. That is not so. We perceive with more than our eyes. In this case, Amber Mack perceived with her ears. And she knew, based on what she was hearing, that Susan James was being hit with a stick. Of all people on earth at that moment, she knew exactly what that sounded. And she heard it over and over and over again, not for 13 seconds, for 4 minutes. I could hear the thuds and her moaning from pain. He then said, "Don't even try and get up because I'll kill you." He yelled back to us that he was going to kill us. And that's when Quanah, whom he had earlier told, "Stand at the door and not let us out," Quanah then walked away. And we know that Quanah has been there for at least 4 minutes, holding Amber Neff, holding Big Squirt, and apparently holding Lisa against their will. Quanah then walks away, and I told Amber now still, I told Big Squirt to lock the door, and he did. I pulled the screen out of the window, and I jumped out of the window, and so did he. I jumped over the fences of the backyard and ran down to the yellow store on Cameron Alexander. That's where she met the girl that called 911. And you've already heard the 911 tape. I will not play it again. I'll simply ask you to remember how small Amber Neff's role was and what it was that she did. She cried. She cried. She was hurt, and she cried. And 16 minutes later, oh, okay, help me out with the math. 51 to 6, that's 9 and 6. 15 minutes later, the Atlanta Police Department shows up at 592 Brawley. And what's the objective evidence that we have? Maybe we have objective evidence that my clicker still doesn't work. At 8:34 a.m., little squirt crawled through the window of the house at 592 Brawley. At 8:51 a.m., almost ironically, a 911 call was made from about, Officer Jackson said about a block away, and the defendant leaves the house. the judge is going to talk to you about what reasonable doubt is. She's going to tell you that no person can be convicted of any crime unless and until each element of the offense is proven beyond a reasonable doubt. Ladies and gentlemen of the jury, the judge is going to tell you that reasonable doubt means exactly what it says. A reasonable doubt is a doubt of a fair-minded. This is your job, by the way. Up until now, this is all preparation for you to do the real work of the justice system. Isn't that funny? All of us are up here dressed in suits and ties and acting like we're important, and we're not doing the real work. We're preparing you to do the real work, because the real work is the work of fair-minded, impartial jurors, honestly seeking the truth, to tell all of us what the truth is. And if you want to know why we put you through that voir dire where we were prying into your personal lives a lot more than you thought we should have, and frankly, a lot more than I was comfortable with at times, it's because we're trying to find the most fair-minded, the most impartial, the people who, for whatever science, art, we think there is to this practice of law, will honestly seek the truth. A reasonable doubt is a doubt based upon common sense and reason. A reasonable doubt does not mean a vague or an arbitrary doubt. It is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. So since the law talks about elements, I think it's helpful that you know what the elements are. Elements are something that only lawyers talk about, well, lawyers and chemists. No, this isn't chemistry, this is law. To aggravated battery, there are 5 elements. How many of you heard me ask the same stupid lawyer question to all but one of the law enforcement officers? Did you catch it? Is 592 J.P. Barwick in Fulton County? Really? It's not really? Why am I asking that? Because one of the elements is that the crime had to be committed in Fulton County. And evidence, testimony from witnesses is evidence. So when those law enforcement officers that we presume know the boundaries of Fulton County because, hey, that's their job, tell us, hey, guess what? That's in Fulton County. We're taking that as evidence of the very first element of every single offense. The offense had to be committed in Fulton County. That's called venue. And venue is one of those things that the judge will instruct you must be proven in every case. And that's why I asked that stupid lawyer question over and over again. That an identified person, little squirt, maliciously caused bodily harm to another identified person, Susan James Deeper. And she testified to the harm that he caused as he beat her for 4 minutes. As he hit her again and again and again. And Susan James is married. And Susan James has obviously suffered a traumatic brain injury. And I don't know how her addiction and the injuries that she has suffered have affected her recollection, her grasp on the land, or anything else. I do know Because all you have to do is look at it. And you have the objective evidence you need. So element 3, bodily harm. That's an element 4, that it seriously disfigured her face. The objective evidence comes from the GPS. It comes from the unsolicited testimony of Amber Neff, her statement in 2017. It comes from the injuries. It comes from the photographs that were taken. Could the investigation have been much better? Yeah. Was it? No. Aggravated assault. Again, venue in Fulton County. That person, little squirt, on a date certain, September the 5th of 2017, assaulted a human being. Earlier, I went over what an assault is. It means that he hit her with something likely to cause serious bodily injury. And that's the 4th element, with an object, device, or instrument which, when used offensively, is likely to, or in this case, actually does, result in serious bodily injury. And the way that it's indicted as that thing was a stick. Was it a stud? Probably not. Was it a decorative piece of something that used to be in that house? Maybe so. But when you look at it laying there, it's obviously capable of doing what it did. He's also charged with aggravated assault on Amber Neff. First elements, actually all the elements are the same. Only the injury is different. What's the injury to Amber Neff? We can see it on the bruises in her legs. You don't need anything else. You have all the objective evidence you need. False imprisonment. First 3 elements are the same. In Fulton County, that person, on September the 5th of 2017, in violation of the personal liberty of another. How many of you feel like your personal liberty is being violated? Don't answer that. Simply wouldn't let her go. Told his girlfriend, hold them there. Was it his girlfriend? Was it his 5'0" girlfriend that held him there? No. Not any more than your alarm system or your home security system protects your home. All that is an early warning device. What held them there was that defendant. Was his threat. Nobody's leaving till I find my goat. And his obvious willingness to enforce it with extreme violence. Don't fall into the fantasy world that the defendant would have you fall into. It wasn't Quanah that held him there. Quanah was simply the early warning system if they tried to escape. The defendant held them there with his threat, which he had already proven he would carry out. They would suffer if they left. And when it became apparent that the early warning system wasn't working anymore, they hightailed it out of there. Out the window they went. How do we know that these injuries weren't inflicted by the defendant's father? That's a sick fantasy. Because the defendant's father was being held in the back room. It was impossible for him to reach out from that point and inflict the injuries on Susan James. Or for that matter, on Amber Neff. Why? Because we have exactly how that happened. There's no question about that. And the final is without legal authority. We heard, why was I asking the questions about do you have arrest power? because hardly anyone in our society has arrest power. That's power reserved for those that we believe will use it responsibly. Do they always use it responsibly? Unfortunately not. But we hold police officers to that standard because they have that legal authority. And if you don't have that uniform and that shield, you don't have that authority.
You have about 2 minutes.
That authority. 2 minutes? Thank you, Mr. Hudson. Thank you, Judge. Ladies and gentlemen of the jury, trial by jury is democracy at its most basic level. In this artificial environment of the courtroom, with admittedly incomplete facts, we ask you to make a decision, one case at a time, that will shape our community, one case at a time. Your job is to be fair-minded, impartial, and honestly seek the truth. If you seek doubt in any case, you'll find it. You can find doubt in vague reasons, in arbitrary reasons, in fantasy reasons. But your job is not to engage in the vague, arbitrary fantasies that the defense would ask you to engage in, but rather is to honestly seek the truth. To honestly look at the 17 minutes that changed everything, and to find the defendant, Leon Jones, low squirt, guilty on all counts. That is the verdict that will speak the truth. That is the verdict that will do justice. And now, ladies and gentlemen of the jury, after 3 days, it's time for you to go to work. Thank you for your service.
All right, thank you, Mr. White.
Oh, let me take that down.
All right, ladies and gentlemen, it is now time for me to read you the law that you are to use to, yes,
Could we clear the screen?
yes. While Mr. White is doing that, I have one question for you first. It is now time for me to read you the law that you are to use in applying to the facts of this case as you have heard those facts. This takes me about 15 to 20 minutes. Do you want to go straight through or do you want to take a break? Entirely up to you. Straight through? You okay, Samantha? You okay? All right. I am going to remove my mask. Is it okay with you if I remove my?
Yeah, we're still.
Okay. All right, ladies and gentlemen. We're considering the case of the state of Georgia versus Leon Jones. The grand jury has indicted Mr. Jones as follows. The grand jurors selected, chosen, and sworn for the county of Fulton, to wit, in the name and behalf of the citizens of Georgia, do charge and accuse Leon Jones with the offense of aggravated battery, OCGA section 16-5-24, for the said accused in the county of Fulton and state of Georgia on the 5th day of December 2017 did maliciously cause bodily harm to Susan James by seriously disfiguring her face, accused having accomplished this act by striking Susan James, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 2. And the grand jurors aforesaid in the name and behalf of the citizens of Georgia do charge and accuse Leon Jones with the offense of aggravated assault, OCGA section 16-5-21, for the said accused in the county of Fulton and state of Georgia on the 5th day of September 2017 did unlawfully commit an assault upon the person of Susan James by striking Susan James with a stick, an object which, when used offensively against a person, is likely to result in serious bodily injury, contrary to the laws of the state, the good order, peace, and dignity thereof. Count 3. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, do charge and accuse Leon Jones with the offense of aggravated assault, OCGA section 16-5-21, for the said accused in the county of Fulton and state of Georgia on the 5th day of September 2017 did unlawfully commit an assault upon the person of Amber Neff by striking Amber Neff with a stick, an object which, when used offensively against a person, is likely to result in serious bodily injury, contrary to the laws of said state, the good order, peace, and dignity thereof. Count 4. And the grand jurors aforesaid, in the name and behalf of the citizens of Georgia, do charge and accuse Leon Jones with the offense of false imprisonment, OCGA section 16-5-41, for the said accused in the county of Fulton and state of Georgia on the 5th day of September 2017 did unlawfully detain Amber Neff without legal authority and in violation of the personal liberty of said Amber Neff, contrary to the laws of the said state, the good order, peace, and dignity thereof. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. Defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with a presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatever, and the burden never shifts to the defendant to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, a conflict in the evidence, or any combination of these. If, after giving consideration to all the facts and circumstances of this case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on the law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. Your oath requires that you decide this case based on the evidence. Evidence is the means by which any fact which is put in issue is established or disproved. Evidence includes all the testimony of the witnesses and the exhibits admitted during the trial. It does not include the indictment, the plea of not guilty, opening or closing remarks by the attorneys, or questions asked by the attorneys. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts which are reasonable and justified in the light of your experience. It is evidence that only tends to establish a conclusion by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conviction on circumstantial evidence, the proven facts must not only be consistent with the theory of guilt, but must exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based upon circumstantial evidence than upon direct evidence, whether dependent upon direct evidence or circumstantial evidence or both. The true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you must convict. You may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. You must determine the credibility or believability of the witnesses. In deciding credibility, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility insofar as you observe it. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. Taste or touch. That is said to be circumstantial or wait a minute, let me start over. When direct evidence, let me start over one more time. Direct evidence is that which may be seen or heard or otherwise directly sensed, such as by smell or taste or touch. It may be brought into court in the form of exhibits or the testimony of direct witnesses to such matters. It is evidence that points immediately to the issue in question. When direct evidence by inference points to, I believe this is duplicative of another charge, but I'm going to go ahead and finish reading it. When direct evidence by inference points to an obvious, likely, or reasonable conclusion, even though that conclusion was not directly seen, heard, smelled, tasted, or touched, that is said to be circumstantial or indirect evidence. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. It is evidence that only tends to establish a conclusion in question by its consistency with such conclusion or elimination of other conclusions. Sometimes circumstantial evidence may point to more than one conclusion. To authorize a conclusion on circumstantial evidence, the proved facts must not only be consistent with the theory of guilt, but also exclude every other reasonable theory other than the guilt of the accused. The law does not require a higher or greater degree of certainty on the part of the jury to return a verdict based on circumstantial evidence than upon direct evidence. Whether dependent upon direct evidence or circumstantial evidence, the true test is whether there is sufficient evidence or whether the evidence is sufficiently convincing to satisfy you beyond a reasonable doubt. If not, you must acquit. If so, you may convict. There is no rule that either circumstantial or direct evidence is stronger than the other if conflicting. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion on the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. In determining the credibility of witnesses and any testimony by them in court, you may consider where applicable. Evidence offered to attack, cast doubt upon, challenge the credibility or believability of any such witness. This would include evidence of character for untruthfulness, shown by specific instances of conduct of the witness in question, brought out on cross-examination of that witness that may relate to that witness's character for untruthfulness, bias toward a party, specific instances of conduct of the witness that may relate to the witness's bias toward a party, felony conviction, proof that the witness or witnesses have been convicted of certain felony offenses, including but not limited to crimes involving dishonesty. In determining the credibility of any witness whose credibility has been attacked, cast doubt upon, challenged, as I have described above, and any testimony by him or her in court, you may consider, where applicable, evidence offered to support the credibility or believability of any such witness. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified, or the credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Sometimes evidence is admitted for a limited purpose. Such evidence may be considered by the jury for the sole issue or purpose for which the evidence is limited and not for any other purpose. Identity is a question of fact for you to determine. Your determination of identity is dependent upon the credibility of the witness or witnesses offered for this purpose. You should consider all of the factors previously charged you regarding credibility of witnesses. Some, but not all, of the factors you may consider in asserting reliability of identification are: 1, the opportunity of the witness to view the alleged perpetrator at the time of the alleged incident; 2, the witness's degree of attention toward the alleged perpetrator at the time of the alleged incident; 3, the possibility of mistaken identity; 4, whether the witness's identification may have been influenced by factors other than the view that the witness claimed to have; and 5, the length of time between the crime and the out-of-court identification. It is for you to say whether, under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify this defendant beyond a reasonable doubt as the perpetrator of the alleged crime, or that the defendant was a party to it. It is not necessary that the defendant show that another person committed the alleged offense. If you do not believe that the defendant has been sufficiently identified as the person who committed the alleged crime or was a party to it, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of this defendant as the person who committed the crimes alleged in this bill of indictment. This defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that 1, the acts of a person of sound mind and discretion are the product of that person's will, and 2, a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such inference or inferences is a matter solely within the discretion of the jury. Any party to a crime who did not directly commit the crime may be prosecuted for commission of the crime upon proof that the crime was committed and that the person was a party to it, even though that person alleged to have directly committed the crime has not been prosecuted or convicted, has been convicted of a different crime or degree of crime, is not amenable to justice, or has been acquitted. Knowledge on the part of the defendant that the crimes alleged in the indictment were being committed and that the defendant knowingly and intentionally participated in or helped in the commission of such crime must be proved by the state beyond a reasonable doubt. If you find from the evidence in this case that the defendant had no knowledge that a crime was being committed, or that the defendant did not knowingly and intentionally commit, participate, or help in the commission of, and was not a conspirator in the alleged offense, then it would be your duty to acquit the defendant. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crimes alleged in the indictment were being committed and that the defendant knowingly and intentionally participated or helped in the commission of it, then you would be authorized to convict the defendant. A jury is not authorized to find a person who was merely present at the scene of the commission of a crime at the time of its perpetration guilty of consent in and concurrence in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. A jury is not authorized to find a person who was merely associated with other persons involved in the commission of a crime, guilty of consent in or concurrence in the commission of the crime, unless the evidence shows beyond a reasonable doubt that such person helped in the actual perpetration of the crime or participated in the criminal endeavor. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. A person commits the offense of aggravated assault when that person assaults another person with a deadly weapon that, when used offensively against a person, is likely to or actually does result in serious bodily injury. To constitute such an assault, actual injury to the alleged victim need not be shown. It is only necessary that the evidence show beyond a reasonable doubt that the defendant intentionally committed an act that placed the alleged victim in reasonable fear of immediately receiving a violent injury. The state must also prove as a material element of aggravated assault, as alleged in this case, that the assault was made with a deadly weapon that when used offensively against a person is likely to or actually does result in serious bodily injury. A stick, if and when used in making an assault upon another person, is not a deadly weapon per se, but may or may not be a deadly weapon depending upon the manner in which it is used and the circumstances of the case. You may or may not infer the serious injury producing character of the instrument in question from the nature and extent of the injury, if any, inflicted upon the person allegedly attacked. Whether or not, under all of the facts and circumstances of this case, the stick alleged in this bill of indictment to have been used in making an assault upon the alleged victim did, in fact, constitute a weapon likely to cause serious bodily injury is a matter to be decided by the jury from the evidence in this case. In deciding whether the alleged instrument was a weapon capable of causing serious bodily injury, you may consider direct proof of the character of the weapon, any exhibition of it to the jury, evidence of the nature of any wound or absence of wound, or other evidence of the capabilities of the instrument. A person commits the offense of aggravated battery when he or she maliciously causes bodily harm to another by depriving him or her of a member of his or her body, by rendering a member of his or her body useless, or by seriously disfiguring his or her body or a member thereof. A person commits the offense of false imprisonment when, in violation of the personal liberty of another, he arrests, confines, or detains such person without legal authority. An offensive weapon is any object, device, or instrument that, when used offensively against a person, is likely to or actually does result in death or serious bodily injury. The character of a weapon may be established by direct or circumstantial evidence. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did on September the 5th, 2017, commit the offenses as alleged in the indictment, you would be authorized to find this defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of any or each of these offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment which this court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, BlackBerry, or computer, the internet, any internet service, or any text or instant messaging service or any internet chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, or Twitter to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. One of your first duties in the jury room will be to select one of your number as a foreperson who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. Whatever your verdict is, it must be unanimous, that is, agreed to by all. The verdict must be in writing and signed by one of your members as foreperson, dated, and returned to be published in open court. Now, ladies and gentlemen, in just one more moment,